Good day, I am Lady Mae Patac from BSHM 3A, and for today's discussion is all about laws related to tourism investments and finance, Chapter 12. Learning objectives. Enumerate the procedure in setting up a tourism-oriented business. Explain the laws governing tourism investments and financing tourism-oriented projects. Discuss the business models applicable to tourism project. Enumerate the various taxes application to tourism-related establishment, and discuss the limitation of foreigners in tourism investment. So this chapter deals with laws related to promotion, monitoring, and regulations of tourism investment and finance in the country. Basically, these will tackle the participation of foreign investors as well as incentives given to Filipinos in case they will invest in the tourism industry. Special laws are even created to address needs of certain sectors like the informal sector, Filipino balikbayans, retirees and senior citizen. Retirees and senior citizen. So Foreign Investment Act of 1991. So the Foreign Investment Act of 1991 defines the term Philippine national to include individuals, partnership, associations, and corporations meeting certain ownership criteria. Specifically, a Philippine national can be a citizen of the Philippines, a domestic partnership or association wholly owned by Filipino citizens, or a corporation organized under Philippine laws with at least 60% of its capital stock owned by Filipinos. Additionally, a corporation registered in the Philippines with 100% Filipino ownership, or a trustee managing funds for pension or retirement benefits where at least 60% of the fund will benefit Filipino nationals, is also considered a Philippine national. Furthermore, if a corporation and its non-Filipino stockholders own shares in a Security and Exchange Commission or the SEC registered enterprise, both corporations must have at least 60% Filipino ownership to be considered Philippine nationals. So procedures for registration. So this a foreign national or entity not seeking to avail or incentives under the Omnibus Investment Code shall file an application of registration as follows. So first, we have the corporation and partnership with the Security and Exchange Commission. So this involves submitting the necessary documents and informations required by the SEC or the Security and Exchange Commission for the registration of corporation and partnership. Next, we have the single or sole proprietorship with the Bureau of Trade Regulation and Consumer Protection, or the BTRCP of the Department of Trade and Industry. So this entails providing the required documentation and fulfilling the registration required set by the BTRCP for single or sole proprietorship. So in both cases, the applicant must comply with the relevant regulations, submit the required paperwork, and follow the procedures outlined by the SEC or BTRCP to complete the registration process. Investment in transportation, business, and public utilities. So, an example of an investment in the transportation, business, and public utilities that complies with the provision of Article 7, Section 11 of the Philippine Constitution would be a corporation organized under Philippine laws with at least 60% of its capital owned by Filipino citizens. So for instance, a transportation company that operates buses, ferries, or railways within the Philippines could be established as a corporation with majority Filipino ownership. So this corporation would apply for the necessary franchises or certificates to operate as a public utility, ensuring that it meets the citizenship and ownership requirements mandated by the Constitution. Furthermore, the corporation would ensure that its governing body includes equality participations from the general public as encouraged by the state. So foreign investors may participate in the governing body but are limited to their proportionate share in the capital, and all executive and managing officers must be Filipino citizens. In summary, an investment in the transportation business and public utilities would involve establishing a corporation with majority Filipino ownership and complying with the constitutional provisions regarding equality participation, citizenship requirements, and limitation on foreign involvement in the governing body. Next, we have the investment in travel agencies and tour operations. So, investment in travel agency and tour operators in the Philippines is subject to certain accreditation requirements. So, according to regulation, the following entities may apply for accreditation as a tour operation. So first, a resident Filipino citizen. So any individual who is a citizen of the Philippines and meets the necessary criteria for operating a tour agency may apply for accreditation. Next, partnership organized under Philippine laws. A partnership entities that is established according to the laws of the Philippines may seek accreditation as a tour operator. At least 60% of the partnership capital must be owned by the Filipino citizen. And lastly, corporation organized under Philippine laws. So, corporations that are incorporated under Philippine laws are also eligible for accreditation as tour operators. So, to qualify, at least 60% of the subscribed common or voting shares of the corporation must be owned by Filipino citizen. Additionally, the composition of the corporation's board of directors must consist of at least 60% Filipino nationals. So in summary, investment in travel agency and tour operators in the Philippines requirements compliance with accreditation criteria, including Filipino ownership and representation in partnerships and corporation. Next, application of the retail trade law for restaurant and shops. So, restaurant and other tourism-related establishments such as department stores and shoes are governed by the laws on retail trade by reason of the natural nature of their business. So in the past, operations and ownership of these establishments are confined only to Filipino citizens or to corporations and associations fully owned by Filipino citizens. So by reason of the enactment of the Retail Trade Liberalization Act 2000, foreign investors may now engage in retail trade subject to capital requirements refers to the Chapters 5 laws regulating restaurant and other tourism-related establishments. So the retail trade law, particularly the Retail Trade Liberalization Act of 2000, has enabled foreign investors to participate in the operation of restaurants and shops in the Philippines. So expanding opportunities for investment and promoting economic growth in the retail sector. Next, we have the tourism project under the Build, Operate, and Transfer. So tourism project Build, Operate, and Trade Transfer or the BOT program are governed by the Republic Act number 6987 as amended by Republic Act 7719, commonly known as the BOT law. So this legislation refers to the government's acknowledgement of the vital role played by the private sector in driving national growth and development. It aims to leverage private resources by providing favorable incentives to mobilize investment for infrastructure and development projects. So the BOT laws covers not only government infrastructure projects but also government development projects. So it offers various schemes to facilitate partnerships between the government and private sector entities for the implementation of these projects. So the following are the schemes recognized under the law. So first we have the build and transfer. So in the build and transfer schemes, a private entity undertakes the construction of a project such as a tourism facilities or infrastructure or at its own expense. So once completed, the private entity transfer ownership of the project to the government or another designated entity. So the government or designated entity then assumes responsibilities for the operation and maintenance of the project. So next, we have the build, lease, and transfer. So is a private entity constructs a project and leases it to the government or another entity for a specific period. So during the lease term, the lease government or entity pays lease payment to the private entity for the use of the project. So at the end of the lease period, ownership of the project typically transfer to the lease. Next, we have the build, own, and operate. So in the build, own, and operate model, it is a private entity finances, constructions, and own the project. So the private entity operates the project and may generate revenue through user fees, tariff, or other income streams. The private entity retains ownership of the project throughout its operational phase. Next, we have the build, operate, and transfer. So it involves a private entity financing, constructing, and operating a project for a specified period. So during the operational phase, the private entity is responsible for maintaining and operating the project, often collecting revenue directly from users. So at the end of the agreed upon term, ownership of the project typically transferred to the government or another designated entity. So next, we have the build, transfer, and operate. So it is a private entity constructs the project and transfer ownership to the government. So following transfer, the private entity is then granted the right to operate and maintain the project for a specified period, so often under the concession agreement. Next, we have the contract and operate. So it is a private entity enters into a contract with the government to add additional services or operations to an existing project. So the private entity assumes responsibilities for the added services or operations while operating under the terms of the contract. Next, we have the develop, operate, and transfer. So it involves private entity financing, developing, and operating a project for a specified period. So after the operational phase, ownership and control of the project transfer to the government or another designated entities. Next, we have the rehabilitate, operate, and transfer. So under it is a private entities rehabilitates an existing project such as a tourism facilities or infrastructure. So the private entity then operate the rehabilitated project or for a specified period before transferring ownership and control to the government or another entity. Next, we have the rehabilitate, own, and operate. So it is a private entity finances and undertakes the rehabilitation of an existing project. So the private entity retains ownership of the rehabilitated project and assumes responsibilities for its operations and maintenance. Next, we have the franchising. So a franchise is a business arrangement in which a dealer known as the franchisee is granted the right by a franchise service organizations known as the franchisor. So to sell the franchisor's products or services within the specified territory. These agreements may include the use of trademarks, trade names, and other intellectual property owned by the franchisor. So The franchise agreement is a contractual document that formalizes the relationship between the franchisor and the franchisee. So it outlines the terms and conditions under which the franchisee operates the business, including provisions for consultations, promotional support, financing, and other benefits provided by the franchisor. So, in exchange for the right to operate under the franchisor's brand and utilize its resources, the franchisee typically pays a franchise fee to the franchisors. So, this fee may cover initial startup costs, ongoing support services, and access to the franchisor's proprietary system and technologies. Additionally, the franchisee is usually recognized to adhere to certain standards set by the franchisor, including using specified products or services provided by the franchisor. So, this helps maintain consistency and quality across all franchise locations and ensure a uniform customer experience. And that ends my discussion. This is Lady Mae Patac. Thank you and have a good day.